Get ready. 5 seconds to go. Start. The court below ought to have considered the evidence of PWs 2, 3, and 4. Stop. The appellate court, without going into the validity of the evidence adduced on behalf of the prosecution in a stereotyped manner, confirmed the judgment of the trial court, and the courts below failed to notice the non-examination of motor vehicles inspector stop. The revision petitioner prayed for setting aside the conviction and sentence passed against him by allowing this revision stop. During the course of hearing of the revision, the learned counsel for the revision petitioner reiterated the contentions raised in the grounds of revision stop. He submitted that except PW1, the police constable, and PW9, the investigating officer, all other witnesses turned hostile to the prosecution, and that even according to prosecution, PW6 is an eyewitness to the accident and his evidence belies the evidence of PW1. But the courts below ignored the evidence of PW6, and that the appellate court erroneously held that the evidence of PW6 supported the case of the prosecution, though PW6's evidence does not support the case of the prosecution stop. He further submitted that there are no crush injuries found on the deceased, and that if really the deceased was hit by the bus from his behind and ran over the deceased, there should have been crush injuries, and that on the other hand the injuries were found on the entire right side of the deceased, which supports the evidence of PW6 that the deceased himself fell down from the cycle on the rear side of the bus stop. He further submitted that there is discrepancy in the evidence of PWs 1 and 9 regarding the distance from where PW1 was standing to the place of accident stop. According to PW1, he witnessed the accident from distance of 10 feet, while according to investigating officer, the distance was 25 feet stop. He further submitted that there is absolutely no evidence to prove the alleged rash and negligent act on the part of the driver of the bus, and that evidence of conductor PW3 goes to show that it is only on account of cries from the passengers sitting rear side stop. The bus was stopped, and then they got down and found the cyclist with injuries stop. He further submitted that the circumstantial evidence noted in the forum of observation report clearly goes to show that there was no scope for PW1 to witness the exact manner in which the accident took place. In the further, the medical evidence also belies the solitary testimony of PW1, and therefore the appreciation of evidence by the courts below is perverse, and hence it warrants here in after interference by this court stop.